Good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Barajas Vargas. Could you state your name for the court?
Kevin Barajas Vargas.
Your Honor, in this matter, we are requesting a preliminary examination date. I would ask to address bond.
Of course you would. Is all discovery complete?
So the only question I had, and I emailed Ms. Tanha about this, we requested the 911 call last time. I'm not sure. I was just trying to see if we got it through on base. But I feel confident that we'll be able to get it before the exam.
All right, there will not.
Thank you.
There will not be an adjournment for that purpose.
Understood, Your Honor.
So people have their witnesses available the 13th. Preliminary examination in person, May 13th, 2025, 9 a.m. before Judge Valvo. Yes, as to bond.
Thank you. So in this matter, my client is prohibited from contacting his 3-year-old daughter as well as his mother and his daughter's mother. He is charged with count 1, which is the felony child abuse. For the allegation is throwing his daughter out of the door. That being said, the CPS investigation has now been closed. The body worn camera shows, and I know, it's not a trial date today, but that even the daughter's mother, denied even a medic to look. She said she's fine. She said it didn't happen when the daughter was trying to tell the police what happened. There's a lot of issues here. My client is even willing to do any sort of supervised visit if the court would even allow that to allow him to contact his daughter. This is the longest he's gone without even seeing his daughter in her entire life, and it's really difficult for him. So that would be our main request as to bond modification.
Response.
Your Honor, contact with the child victim is simply not appropriate at this time. She was 3 years old, and the report states that when they were co-parenting, him and the mother of the child, and when they showed up, he was yelling at the mom, asked her to leave, pushed her, and then he grabbed the 3-year-old child under her armpits and threw her from inside the house outside the house, and she landed on her back and was screaming and crying. I don't think it's appropriate for him to have a contact, even supervised contact, at this point during the pendency of this case, which is charged as a child abuse murder.
Anything else?
I think the only difference between his initial arraignment and now is we have the body worn, which shows that the mother said, basically denied the child's allegation. She said there's no injuries, no need for anybody to look at her. She's completely fine. CPS has now closed the investigation when my client signed a safety plan with them. So I think it is excessive for him to not even be allowed to have any contact with her whatsoever, not even a phone call. This is, so I would submit on that.
I'm going to wait for the point at which there's testimony, or at least Judge Valvo can look at it. So at this point, motion for bond modification is denied.
Thank you, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Thomas, who's making his way to the podium, Judge. Your Honor, there was a bench warrant issued in this matter. Mr. Thomas did turn himself in Tuesday. Tuesday. I've had a chance to discuss this matter with Mr. Childers. I believe that we're going to have a resolution involving a misdemeanor and no objection to HIDA on this. This is so I'd ask the court for a brief adjournment of this probable cause conference so that we can get the paperwork together. I'll do a green sheet immediately after we do this hearing.
Couple weeks.
Yeah, that would be fine, Judge.
Probable cause conference, May 15th, 2025.
Thank you. If I could be heard on bond. Your Honor, Mr. Thomas is here. There was a bench warrant issued for failure to test. Mr. Thomas, he had gone on a family vacation. He came back. He injured. He works at Amazon. He injured himself at work. He had a medical appointment that day. He did try to get here to test. He didn't. He spoke with Mr. Warren Green. Mr. Green told him to turn himself in. He did. He is gainfully employed still at Amazon. He lives with his family. He attends Macomb Community College. Prepared to test either here at Community Corrections or if we can arrange somewhere.
Why didn't he go over and test?
You know, Your Honor, he lives in Macomb, Michigan, and he tried to get over here in time, and it's it's a long, my understanding of where it is it's kind of north Macomb County. It's a long ride in the best of circumstances right now. I think 696 is torn up. He just didn't get here. So he did turn himself in Tuesday because transportation issues didn't allow him to do it yesterday. So he turned himself in Tuesday because that's when he could get here. But he is prepared to, he does have transportation now. He is
So
prepared to
he
test.
returned from the Bahamas on the 21st, right?
I believe so, Judge.
So he couldn't get to test 22nd, 23rd. I mean,
That, I think he had some confusion. He has no criminal history. I think he had some confusion about the actual testing procedure. He thought he would, there was a color he was supposed to do. I am prepared to help him negotiate that.
no. Couldn't have had that. Because when I gave him permission to go, specifically, he was to come back and take an EGG. And then he never showed.
Oh, okay. Your Honor, I'd ask the court to excuse that failure and allow him an opportunity to demonstrate to the court that he is a good bet to both appear and to test as required by the court. Like I said,
He's supposed to come back and test. I mean, I let him go. And then he just didn't do it. And it's not, I mean, he came back on the 21st, which is, well, he came back and was supposed to test on the 21st, but he didn't, that would have been a Wednesday. And he said he couldn't get here from Macomb those 3 days.
Yes,
So
Your Honor.
somehow or another, he got himself to the Bahamas, but he can't get from Macomb County to Washington County. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
And good morning, Your Honor. May it please this honorable court. Oh, well, I'll yield the floor to someone.
You're already.
Oh, okay. Good morning, Your Honor. For the record, Rita Young appearing on behalf of Miss Amanda James, who is present and standing to my right. And today is the date and time set for a probable cause conference, Judge. And there has been an offer made. I don't know if the court's received the printout yet.
I have. I've received a plea sheet that indicates she's going to be pleading to 3 misdemeanor charges.
Yes, Your Honor.
They stated count 3 of operating with the presence of a controlled substance, the crime of operating either with no license or multiple licenses, that's count 4. And then also an added count 5 of use of a controlled substance, a 1-year offense. On her successful plea to those guilty plea to those charges, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
And Judge, there was an agreement by Mr. Childers and myself that she could be sentenced under 7411, but the plea form indicates it's only applies to count 5. And I asked that he agreed that it also apply to count 3, which is the presence of.
And Your Honor, it can't, as the court's aware,
Yeah, I didn't.
7411 doesn't.
I don't think it can.
Very well done, Your Honor. I believe that my client wishes to proceed with the offer. She has been
Did
advised.
she sign an advice rights form?
No.
All right, I'll get you to sign one.
Your advice, we don't know. Just sign.
With
Yep.
Let's have her sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth. You got
I
it.
do.
State your name.
I'm Anthony.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 3 charges. Is that your understanding?
Sharon.
All right. First of all, that you'll be pleading guilty to the charge of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Also, then count 4, operating with no license or multiple licenses, that's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes.
And then also the added count 5 of use of a controlled substance, that's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you'd be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes, Sharon.
All right. Now, understanding all of that, ma'am, do you still wish to plead guilty to these charges?
Yes, Sharon.
To the charge of operating with the presence of a controlled substance, how do you plead?
Guilty.
To the charge of operating with no license or multiple licenses, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights for every day, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
because you believe that you're guilty of these charges?
Yes.
On February 9th, 2024, at the location of Ann Street in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
Was that cocaine?
Yeah.
All right. Were you stopped by the police or was there an accident?
I was approached by the police while airing my tire. I'm not sure if they seen me exiting my vehicle prior to them approaching, but
They approached you because there was no air in your tires?
I was pulled over on the side of the.
Side of the road because your tire had gone flat? Okay. And after they approached you, were you ultimately arrested?
I was detained, yes.
Pardon?
Yes,
All right. Were you taken to the hospital for a blood draw?
yes,
Did that blood draw show the presence of cocaine and or its derivatives?
yes.
All right. Do you have any reason to dispute those blood test results?
No,
All right. And at the time that you used the cocaine, you knew what you were using was cocaine?
yes,
Pardon?
yes,
All right. And at the time also that you operated the motor vehicle, did you have a license?
No.
Okay. Never had a license?
I've had a license, it was just
But
suspended.
at that point, had no license. Is that
Correct.
correct? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people.
Yes, Your
have
Honor.
satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report as well as screening assessment is ordered at 14A2 probation. Sentencing will be May 14, 2025, 10 a.m. before Judge Barr.
May I address bond, please?
Can I stop you? No, go ahead.
Of course you can. Miss James, she's 45 years old, Your Honor. She resides at the address that's listed in her file. She's a certified nurse assistant and provides home care to a patient that she's had for 7 years. Her bond is currently set at 10,000 cash or surety, and that was because she appeared by Zoom for probable cause. No, she appeared by Zoom for an arraignment and then thought she could appear by Zoom for the probable cause conference, was told that she could not make it to court in time. Her attorney was not able to get a new date, so the bond was increased to $10,000 cash as surety. We're asking the court to please reinstate her $5,000 personal bond, which the court set on July 9th of 2024.
How did she come into custody?
Driving without license.
When the police came into contact with her, when she had pulled over and was filling up the tire on her
No, just recently.
car.
No, but then
When were
she,
you arrested the last time?
I
how did
just-
she just
brought
recently
in.
come into custody?
I was-
She didn't come immediately back to the court.
Yeah, no, I was in a vehicle.
No, Your Honor, she did not. She
I was-
said that she thought that her attorney at that time would be able to get her a new PCC date, but then her attorney withdrew. And then I was assigned on January, I think it was 9th of 2025. And then that's when she had been taken into custody around sometime in January.
No, I just came.
No,
No, I was in a vehicle that was pulled
so,
over.
and it was pulled over.
Yes,
And you knew at the time that it was pulled over that you hadn't shown up for your court date.
yes, I
So
didn't.
why didn't you come in?
Well, I did. I came in
Well,
with that.
now, yeah.
Yeah, well, at the time prior to me being pulled over, the attorney I had, Chelsea, I can't think of her last name, she's a public defender. She advised me originally, I was on the phone
She
with her
advised you originally.
to not come, to not turn myself in.
Oh, really?
She did, and then
She
she
did?
quit.
So she told you,
And then
just
she,
don't come to the court
until after Christmas.
until
I-
after
yes.
Christmas.
Yes, and then she quit.
Why would she say that?
For the same reason that she wouldn't tell you I was on the phone with her while she was here in court.
Excuse me? Oh, she was just out to get you.
I'm not saying she was out to get me. I'm saying that
She wanted
there
you
was
to
just
spend Christmas.
miscommunication. There was a
So
miscommunication.
she told you not to come in until after
She
Christmas,
told me to hold off on turning myself.
until after Christmas. Right?
Her words were,
I'm now on May 1st. When did you get picked up?
9 days ago.
9 days ago? That's well after Christmas.
Well, she had quit, Your Honor.
So,
I didn't
other
have
than the
enough.
other false statement you made about Mr. Shields, are you saying she told you to stay out till that point too?
I didn't have an attorney.
Oh,
I was informed by the.
oh, you're
Judge,
just put
I
on that
think she was-
advice? Yeah, okay.
Yeah, Your Honor,
I think
don't
she
wanna
was
make-
taken into custody before then because they would not have assigned me. I have proof that I was assigned on January 9th of 2025. So,
So where's she been since January 9th?
were you released and then failed to appear again?
Like I explained to you after.
And then 9 days ago, she gets picked up.
Judge, it's kind of bizarre what's been going on. with-
Pardon?
It's a little bizarre what's been going on.
Oh,
with
yeah.
the Case,
have-
and we both apologize,
Yeah.
but she has one prior conviction that was in 2025 years ago,
Don't
Judge.
blame, you know what?
I'm not
Here's
trying
my
to
problem.
blame.
I almost would buy your story, but
I'm not
you're
trying to
not
blame.
gonna blame Ms. Rios for you
Well,
not.
no,
appearing. You
I'm
decided
not.
that you wanted to stay out, you wanted to
I
be
did.
out till Christmas. She did
I
not
did.
tell you that,
no,
and then
I-
you just continued to stay out. So
Yeah, I'm not trying
motion
to
for bond
blame.
reduction denied, bond will continue. Thank you.
Very well, Your Honor, thank you.
Ms. Virgils, that was so nice of you to make sure she could celebrate Christmas. Court calls the case.